Now, in today's video, we're going to be talking about the very recent Supreme Court decision in US v. Rahimi, a case dealing with civil restraining orders. So, to begin with, let's sort of discuss this particular term of the US Supreme Court. There were two major focused Second Amendment related cases before the court this term. We got a decision a couple of weeks ago in US v. Cargill that deals with bump stocks. And as it turns out, it wasn't really about the Second Amendment. In fact, Justice Thomas, when he wrote his opinion, he focused exclusively on federal regulatory overreach, essentially saying that the executive branch of the government went outside its scope of constitutional authority in making bump stocks illegal. As many of you guys are aware, after the Bruen decision, a new constitutional test was established to determine whether or not a statute runs afoul of the Constitution. This is referred to as the history, text, and tradition test. We were expecting, at least, that in Cargill we would have a Bruen analysis performed, and it wasn't to take place. Justice Thomas didn't feel the necessity to even bring up the Second Amendment in that case. Now, that put a lot more interest in this case that we're talking about today, US v. Rahimi, because this would be the other potential Second Amendment case where we would get a kind of the contours of the Second Amendment, if you will. Or if, as many commentators suggested, the Supreme Court was going to go back on its original decision in Bruen and sort of modify the test, it was most likely going to happen here. This case was, the opinion at least, was given out by the Chief Justice of the U.S. Supreme Court. Justice Thomas issued a dissent. Now, every other justice on the court either agreed with the opinion or alternatively wrote concurring opinions, and then there was various justices that joined in the different concurring opinions. The actual opinion, the controlling authority, does in fact go through a Bruen analysis. That is quite good. We'll call that a win, so to speak. The outcome of the case I fundamentally disagree with. I think that Justice Thomas in his dissent was actually far more articulate in explaining how a civil restraining order is not sufficient to strip someone of a Second Amendment right, that the regulatory traditions that existed at the time of the ratification in 1791 were not sufficiently analogous to this modern restriction. That being said, I think it's important to go through the thought process of the court, see what they were saying, but more importantly, look at the concurring opinions, because there are two concurring opinions that actually I think might be more valuable than the actual opinion itself. So in the original opinion, Justice Thomas, Chief Justice Roberts essentially says that Mr. Rahimi was in fact ordered as a result of a tribunal not to be in possession of firearms for a very specific period of time. He chose to ignore that. He was in possession of firearms, and as a result, he was convicted under federal law for violating that restraining order. Okay, so much so good. He challenges that law, that federal restriction, and he challenges it based on what is referred to as a facially invalid statute. All right, a little explanation, and this gets sort of nuanced, but it is important to understand. Whenever someone challenges a statute, whether or not it's a Second Amendment statute, a First Amendment statute, whatever, okay? When someone challenges a statute as running afoul of the Constitution, they essentially have two pathways available to launch their challenge. They can either claim that the statute is facially invalid. What essentially that means is that there is no way under any circumstance that this statute would not run afoul of the Constitution. When someone launches a facially invalid argument, it essentially limits the court to what it can do. They find that there is one potential situation where the statute might actually be constitutional, then by definition the challenger fails to persuade. On the other hand, there is a less restrictive way of essentially arguing that a case, or a statute rather, runs afoul of the Constitution, and that is referred to as an as-applied statute. Effectively, what the petitioner is arguing that this statute, as it is being applied to them, is unconstitutional. It may be constitutional under certain circumstances, but as it relates to this particular case, it's unconstitutional. This gives the court a lot of wiggle room, because the court can then sit there and say, okay, well, we're going to go ahead and agree with you, Mr. Plaintiff. It is, in fact, unconstitutional as it relates to your specific case, but we're not going to invalidate it in its entirety. On the other hand, the court could sit there and say, well, yes, you came to us as an as-applied challenge, but in reviewing it, we have decided that the entirety of the statute is unconstitutional. They can flip it, and they can make it a facial, decision. This happens actually quite frequently. When you challenge the law, though, and claim that it's facially invalid, it takes that it takes that opportunity away from the court to be able to decide whether they want to narrowly tailor it to your specific case or whether they want to make it more expansive. In Mr. Rahimi's particular case at bar, he claimed a facially invalid statute. And as a result, the court was kind of like, well, we're kind of stuck. It's either, we're going to completely invalidate it or we're going to allow it to stand. Well, they allowed it to stand. And their argument under Bruin was, yes, Mr. Rahimi has in fact shown under step 1 of the Bruin analysis that his Second Amendment rights have been affected. Now, interestingly enough, and there's a very, very small section in the majority opinion where the court sort of scolds the government. This is an important one. The government tried to end the analysis at one point. At that first step, they said, well, Mr. Rahimi is not a responsible person. He's not part of the people that the Second Amendment protects. Now, had they been successful in that, it would have ended the analysis in its entirety. The court has little tolerance for that. They essentially said, that's absolutely incorrect. He is part of the people. That's important because that actually has the potential of affecting a slew of other challenges to other areas of Second Amendment jurisprudence. There's a number of cases that are before courts where plaintiffs are challenging the validity of certain laws, whether it's AR-15 restrictions, magazine restrictions, and one of the arguments that the state has been making is that, well, these weapon systems fall outside of common use. They don't affect step 1 of this analysis, or alternatively, this individual is a criminal and therefore it falls outside of step 1 of the analysis. The court has signaled that they are going to be very intolerant of that argument. We're going to call that a big win for us. In any event, it then moves to step 2, where the state has to show how this statute is consistent with our nation's history, text, and firearms regulatory traditions that existed in 1791. Well, the court looks at the types of restrictions that existed back then and finds 2 types of restrictions. Number 1 is surety laws, and number 2 are laws of affray. So a surety law essentially said that if someone is potentially going to engage in criminal conduct, is potentially dangerous, then a court could require them to post a bond before carrying a gun or carrying a weapon. Assuming that they engaged in illegal conduct, then they would forfeit that bond. Now, the bond was narrowly tailored. It was for a very specific period of time. It was based on some sort of judicial conclusion. Affray laws were essentially the same thing. They had identified particular individuals that had what would appear to be a propensity towards violence, and they would restrict their ability to carry guns based on that. And the court says, well, these are analogous enough to the modern restriction of stripping someone from their Second Amendment rights pursuant to a civil restraining order. So as a result, we're going to uphold this restriction. Now, Justice Gorsuch, in his concurring opinion, really narrowly tailors this decision. Essentially, he says, yeah, Rahimi screwed up. Okay, he should not have done this as a facial challenge. Okay, he might have come to a different conclusion if we had had the ability to do an as-applied challenge. More importantly, he says, look, as long as this restriction on someone's Second Amendment rights is a result of a tribunal that has engaged in fact-finding, and the restriction is for a narrowly tailored specific period of time, that is going to be constitutional. Well, this is interesting because anyone who's ever had a temporary restraining order levied against them knows that for 21 days at least, their Second Amendment rights have been abrogated. And that is not the result of a fact-finding tribunal. So there may be a challenge to not being able to be in possession of a firearm as a result of simply having a temporary restraining order levied against you. It doesn't go into whether or not the tribunal engaged in a certain level of robustness. Okay, I mean, in a civil restraining order case, that is based on what we call a preponderance of the evidence, 50% plus a grain of sand of evidence showing that the person is a potential danger. It's not based on the criminal standard of beyond a reasonable doubt. So there is an argument to be made that, they really didn't go in to whether or not the standard applied is significant. This may result in secondary, we'll call them like Rahimi Part 2s. We really don't know. USCCA, which produces this video, they are doing a giveaway, and it's really cool. But it is something that does end relatively soon. You're gonna wanna participate. You can read all about it in the description below this video, but you're gonna wanna get on this thing. But the last part of this discussion that I wanna bring up has to do with Justice Kavanaugh's concurring opinion. And I really haven't seen a lot of commentators talking about this. And I think this is probably the most important part of this opinion. In Justice Kavanaugh's concurring opinion, he doesn't talk about Rahimi at all. Instead, he gets upset with other courts that are misapplying the history, text, and tradition standard. More importantly, he criticizes the entire concept of balancing tests that are part and parcel of all constitutional law. Really, for the last 75 years, whenever we would challenge a statute as potentially violating the Constitution, we would employ what are referred to as balancing tests. I won't go into all of the intricacies of this, but suffice to say, there's several different balancing tests, everything that's referred to as rational basis all the way up to strict scrutiny. Every law school student that's taken constitutional law has struggled to understand when it is appropriate to use one balancing test versus another balancing test. And oftentimes it would appear that the judges serve more as policymakers than umpires looking at specific pieces of evidence. They already have in mind the policy that they would like to promulgate. The facts become almost irrelevant to them. And balancing tests, frankly, help facilitate this kind of judicial super legislative, ideal. Justice Kavanaugh effectively said, that crap's done. Okay, you should not be employing balancing tests. This history, text, and regulatory tradition test should be the new standard for all aspects of constitutional law. This directly affects First Amendment cases, Fourth Amendment cases, Eighth Amendment cases. This one's a pretty big deal and is potentially controlling legal authority. We're going to have to see how this ultimately plays itself out and whether or not it becomes distinguishable. Anyways, it is interesting. My law partner and I were having a discussion about Rahimi over the weekend, and he did say something that I think bears a discussion. He said, politics always plays a role at the Supreme Court. And oftentimes there is a certain degree of horse trading that takes place among the different justices. The three anti-gun justices, along with Chief Justice Roberts, were extraordinarily upset about Bruen. Now, Justice Roberts joined in Bruen, but there was some complexity on that. Well, there are still a couple of cases that are yet to be decided this term at the Supreme Court. Trump's immunity being one of them, as well as Chevron. And we don't know how the court is going to ultimately rule. But he thinks that this decision in Rahimi, which by definition was a restriction on Second Amendment rights. I mean, after all, they had to sort of cobble together this intellectual argument that restraining orders are analogous to something that existed in 1791. This may have been a payoff to the three justices, the three liberal justices who joined in the decision for their vote on another decision that we are yet to see. Anyways, it's interesting, somewhat conspiratorial, of course, and we'll have to wait another couple of weeks or maybe even this week to get an understanding of whether or not my law partner was correct. In any event, that's kind of Rahimi. I know it's a complex case, and I definitely encourage you to read all of the different opinions on it. If you have questions, by all means, email me at stephen@artemishq.com. As always, train constantly, train consistently, train repetitively, and train with purpose. Above all else, stay safe.